Hi, I'm Misha Ketchell, editor of The Conversation. For democracy to work, people need to be well informed. That's why we work with academic experts to share their research and explain issues in the news. Everything we do is free to republish, but we need your support. Please donate to The Conversation by going to donate.theconversation.com or following the link in the show notes.
From The Conversation, this is Politics with Michelle Grattan.
Last week, the federal court brought down a decision that found that a transgender woman, Roxanne Tickle, had been discriminated against when she was removed from a women-only social media app. The decision followed a long court saga, and now the case is likely headed to the High Court. The federal opposition, meanwhile, has reacted by saying that a Liberal government would seek to legislate to protect single-sex spaces based on biological sex. The legislation would define this as the sex of a person at their birth. To unpack the case and its implications, we're joined on the podcast today by Margaret Thornton, who is an emerita professor at the Australian National University. She specialises in anti-discrimination law and in social and feminist issues generally. Margaret Thornton, can you give us just a brief resume of this case and its background?
Giggle for Girls was the name of an app set up by Sally Grover so that women could communicate with one another safely online. Registration for the Giggle app involved the inclusion of a selfie. So AI software would then assist Miss Grover in determining whether a person was a woman or not. Roxanne Tickle, a transgender woman, successfully joined Giggle, but was then blocked, presumably before her selfie. After several futile attempts to contact Sally Grover, Miss Tickle lodged a complaint with the Australian Human Rights Commission alleging discrimination in access to goods and services under the Commonwealth Sex Discrimination Act on the basis of her gender identity. The complaint could not be conciliated as Miss Grover was unable to be contacted, and the complaint was terminated. Miss Tickle then initiated court proceedings in the federal court. She was successful and was awarded $10,000 in damages. This was, almost 2 years ago. Giggle and Grover then appealed with a cross appeal by Tickle. The full court has just affirmed the earlier decision and increased the damages to $20,000, which recognised the insulting way that Miss Tickle had been treated by Ms. Grover at the 2024 hearing. They had laughed at an image of her.
Now, why is this case really important? What are the issues at stake?
So what is at issue here is understanding the meaning of gender identity. And in the appeal, the three judges, the full court, then focused on the reasoning of the initial judge in light of the wording of the relevant provisions of the Sex Discrimination Act. They were critical that the judge had based his decision on indirect discrimination, that is, Miss Grover did not have actual knowledge of Miss Tickle's gender identity as a transgender woman. That had been argued. Instead, they all found that Miss Tickle had been directly discriminated against on the basis of her gender identity. That's a very straightforward understanding of discrimination. So she'd been treated less favourably than a cisgender woman, that is, one who had been born a woman. The court rejected Giggle's argument that the Giggle app was a special measure designed to advance the interests of women, because it did not advance the interests of all women, and clearly it discriminated against the interests of trans women.
Now, we think it's likely this case will now go to the High Court. On what grounds would that appeal be launched, and how do you think that might result?
Well, it's tricky to answer that. So the issue for courts is always one of statutory interpretation. That is the interpretation of the law that Parliament has already debated and made a determination about. So in a democratic system, that is assumed to be with the support of the people. While there will always be opposition and naysayers, it's not the task of the courts to resolve such decisions. So appeals to the High Court are not automatic, but any appeal from Giggle and Tickle would almost certainly go ahead because it's such an unusual issue. First time that it's been considered by an Australian court, of this issue. But the issue has become controversial within parts of the community. How would the court decide? Who knows? But do note that 4 experienced federal court judges have already decided in favour of Ms. Tickle on a fairly straightforward interpretation of the Sex Discrimination Act, and that would carry significant weight. On the other hand, only 3 cases on sex-gender discrimination have proceeded to the High Court in over 40 years, largely because of the cost of litigation is totally off-putting to individuals. So the court hasn't had much experience in terms of determining issues of sex or gender, but they are experts in statutory interpretation. And on that basis, one would hope that the decision of the earlier courts would be affirmed.
Now, a lot of this case relies on the changes made by the Gillard government to the Commonwealth Sex Discrimination Act. And the changes repealed reference to man and woman, and instead that government substituted the concept of gender identity. Could you just explain for us the significance of that change and what does it ban people or groups from actually doing?
So it's probably useful to actually refer to the definition in the Sex Discrimination Act, which I think makes it clear the meaning of gender identity, which is defined as gender-related identity, appearance, or mannerisms, or other gender-related characteristics of a person, whether by way of medical intervention or not, with or without regard to the person's designated sex at birth. So you can see that's a very open social and cultural definition of what gender identity means. And so that definition was included along with sexual orientation and intersex in the reforms of the Gillard government. But already there are a number of subsections under the Sex Discrimination Act that I think are important. And it's in the same line that we see then marital status, pregnancy, family responsibilities, for example. They're all examples of sex discrimination. And so anti-discrimination law operates only in the public life, not in private life. And there are very specific areas that are included. They're employment, education, accommodation, and the provision of goods and services. And so that was the latter that affected Giggle Proprietary Limited, was found to be liable.
In the case, several bodies, including the Australian Christian Lobby and the Free Speech Union, sought leave to appear in the court. What were these groups arguing?
Well, they claimed that they had a particular interest. And so the Australian Christian Lobby, for example, submitted that the case would affect its indirect interests in Christian and faith-based bodies that were conducting same-sex activities to the exclusion of transgender women. But it was refused leave to appear. And the Free Speech Union, so its interest was even more indirect. And it claimed that it was interested in freedoms and it was opposed to online groups operating exclusively rather than in a more general sense. And so they were excluded from appearing. And nevertheless, the Lesbian Action Group and Equality Australia were granted leave to appear.
And what were their arguments?
Well, that they had broader interests. So the Lesbian Action Group, there was a case that has also just been handed down. And so that was related to this case because the Lesbian Action Group wanted to meet and to exclude transgender women from attending their meetings. And they were seeking permission to be able to do that. And the other group, the Equality Australia, they were accepted. I mean, they basically support same-sex and trans people, but on a national level. And I think that national dimension seemed to be relevant to the case. Basically, if one's seeking to appear in a court, it has to be to assist actually with the arguments and help the court in some way.
Just to follow up on those groups, it is right, isn't it, that this case has divided feminists. Can you just give us a bit of a feel for that division?
Yes, well, there is this issue which I think the Giggle was pursuing, that they saw women as being women, cisgender women, so that those who were born women were women, and they objected then to trans women. So women who had been born men, but had either had some sex change or had moved then to identify themselves as women. So there is that division.
And has this become a big issue among feminists?
Well, I'm only sort of aware of this indirectly, and here are the particular groups such as this and one or two others I've heard of in London and so on who have been pursuing it actively. But I think for many others, feminist groups tend to be much more inclusive and accepting of transgender women.
Now, after the outcome of this case, opposition leader Angus Taylor said in a statement that a Liberal government would seek to change the law again to go back to the strict definition of male and female being a person's sex at birth. What would those changes mean for trans men and women?
Well, I think it obviously would be seen to be a retrograde step in view of this movement in terms of bringing Australia, into modernity and acknowledging modern liberalism, then recognises differences between people and the object being one of the creation of a fairer and more just society. So I think it would deleteriously affect, trans people in terms of health and well-being. And there's evidence of that already in terms of high adverse mental health and suicidal ideation in regard to those groups, particularly amongst young people. So I think it would be regrettable to move back to that position.
Is there a risk that Angus Taylor's proposed changes would contravene the International Covenant on Civil and Political Rights, which Australia has signed on to, and the court ruled prohibits discrimination on gender identity?
Yes, well, I think that's certainly the case. But also, it's not only that particular covenant, but also the Convention on the Elimination of All Forms of Discrimination Against Women is really the primary UN instrument that underpins the Sex Discrimination Act, and indeed gives it its constitutional basis. So I think that would be a major issue, and it may well be something that the High Court would have to consider if that was seen to be part of the case of Giggle instituting that action, if they proceed with that appeal.
Now, just finally, there have been and there still are controversies around transgender women in sport and in women's prisons. and some bans have been put in place in those various areas. Does this case have any implications for those issues?
Well, I don't think it does directly, because the issue of sport is actually excluded from the Sex Discrimination Act if it's a case of the strength, stamina, or physique of a person. But it continues to be controversial at the wider level. And also, I think that prisons are another ongoing site of contest. They're not directly impacted, but some states, such as Victoria, I know are addressing the issue at the moment. But the indirect effect of Giggle and Tickle could have the effect of encouraging then a fairer and less stereotypical approach in these areas.
Margaret Thornton, thank you very much for talking with us today and explaining this very interesting case. That's all for today's podcast. Thank you to my producer, Ben Roper. We'll be back with another interview soon, but goodbye for now.
Production by Ben Roper. Theme music by Lee Rosevere. The Conversation is a not-for-profit media organisation. Sign up to our daily newsletter for evidence-based news and analysis, including articles from Michelle Grattan, or listen to more of our shows wherever you get your podcasts.
What are you going to have? Can I have 2 pieces of mullet, please, Pauline?
From a fish and chip shop in regional Queensland
We are in danger of being swamped by Asians.
to the heart of Australian politics, this is the unlikely story of the country's most controversial minor party.
Are you xenophobic? Please explain.
For 30 years, One Nation and Pauline Hanson have been ridiculed, dismissed and shut out. Now, no one's laughing.
One Nation continuing to surge in the polls.
Dramatic surge in support for One Nation.
I'm back.
This is The Making of One Nation from The Conversation, and you can search for it wherever you listen to podcasts.